This is Giovanni Di Stefano on the 11th of June 2009 for SLI Media. Now, today I'm going to explain the situation of Charles Bronson. Most of you will think that it's the actor, but of course it's Mr. Patterson. Charles Bronson, the very famous, the artist, because he's an artist, the author, because he's written books, the poet, because he's written poetry, even the singer. He sang a song from high security prison, My Way. Quite interesting. I did the same, but not from the same venue, of course. Mr. Bronson also is the subject of a recent film with Tom Hardy, and it had some very, very good and critical reviews. He is, without doubt, one of the hardest men in British prisons, but he's a good person, has a good heart, and means well there. Now, on the 17th of February 2000, 9 years ago, Mr. Bronson was convicted at Luton Crown Court for false imprisonment. Let's leave aside all of the whys and wherefores there, because it's frankly not relevant for these purposes. Now, Mr. Bronson received a sentence, an indeterminate sentence, discretionary indeterminate sentence of 4 years. So one could reasonably have expected that 2004, 2005, 2006, Mr. Bronson would have been released. Of course, the whole question of indeterminate sentences are a matter that are being reviewed by the European Court en masse, and whether or not they will be upheld, it's a matter to be seen. I doubt very much that it's correct to issue those sentences, but then I would say that, wouldn't I? Some would say. So let's put that to one side and deal with Mr. Bronson. Mr. Bronson was placed then in the highest level security in British prisons. There's something which in the case of Noy was deemed unlawful, and they had to close some of the high security units because they were effectively contrary to the Human Rights Act there. Certainly Mr. Bronson was housed until of late in a special part in Wakefield Prison where there are cages and bars, and he's been treated like an animal. Let me just give you an example. For us to get a doctor in to see him, we have to go to court to get a court order. Absolutely disgraceful. And I think I've gone down on record as saying that the prison service in this case have behaved abominably, and the actual title, Her Majesty's Prison Service, is a disgrace to Her Majesty there. And I'm going to write to Her Majesty and ask that that HM be taken off, because they're not in any way behaving, not just in the case of Bronson, but in a lot of other cases. As Lord Justice May says, they're a law unto themselves until the courts have to intervene, and what a waste of time and money. But in Bronson's case, now some of you may remember a film called Murder in the First. Murder in the First was about a young boy called Henry Young who was badly treated in Alcatraz prison. He murdered someone. Instead of getting the death penalty, he got a sentence of manslaughter, because what the young defence lawyer proved was that the system at Alcatraz prison was partly responsible for the way that he was behaving. And that's exactly the case of Charles Bronson, except that Bronson wasn't Henry Young. He hasn't killed anybody. Remember that. He hasn't killed anybody. He's not a murderer. He's not a rapist. He's not an armed robber. He concedes that he did wrong many, many years ago. Now, the situation with parole is that after a lengthy period, we managed to get an application for parole, and again, one big hoo-ha. David Martin Sperry, that counsel, had to persuade the parole board that he could even come into the room. I mean, that's just how bad. Now, we've been awaiting the results of the parole board, and they came in, of course, today, and parole is denied. However, it's not quite that bad, because what the parole board have said is that they would like more cooperation from Charlie with psychiatrists. But of course, he can't see a psychiatrist because security won't allow him. He can't do classes, we understand that, because security won't allow. He can't do any of the so-called courses that are required for indiscriminate life sentence because security won't allow. So we have the chicken and the egg situation. And we have a man that until of late, until I intervened, and David Martin Sperry and other lawyers have intervened, we wrote and made applications regarding the security aspect, and mercifully, he was moved to Long Lartin prison, so he's downgraded. He's not happy there, of course, because when you are in the cages, you do tend to have special treatment there. And when you go into the general population of the prison population, it's not quite so. It's the difference between a tailor-made suit and one from Burton's, if it still exists now in the United Kingdom, one off the peg, shall we say. So that is the situation. But what the parole board have said, they question his mental ability. Well, now, in parallel, I made an application to the Criminal Cases Review Commission on the basis that, although not many people will know, Mr. Bronson conducted his own trial. Now, part of the trial was the whole question of provocation. Now, that has troubled eminent lawyers for years and years and years, and it's gone as far as the Privy Council. It's gone backwards and forwards like a game of tennis, like Vijay Geritolitis and John McEnroe, without anyone really defining what is and what isn't, and what can and what cannot be provocation there. So you can imagine, we now have a situation where Mr. Bronson conducted his own trial. The judge ruled against him on admitting the evidence of provocation. Very similar to Henry Young, he was saying the system made him as such there. Now, in the case of Sams, a very, very bad and evil murderer and rapist, a judge in another Crown Court allowed it. But the Crown Court in Luton, no. So again, we have a disparity of the application of law, which is of some considerable concern to practitioners like myself, who have to struggle and try and explain to a client why a person in the Crown Court in Plymouth has something and why a person in Luton doesn't. It's very hard. But in this case, we now have something fairly positive here. The parole board have effectively found that Charles Bronson has a problem with being able to understand, being able to comprehend what is right and what is wrong, and requires psychiatric assistance. Well, who wouldn't, after 8 years being in the cages there amongst people like that and being treated like an animal, which is a disgrace to the British system, which never used to be like that, incidentally. It's only of late, since those pen pushers at the prison service that have got into power. I hope they get out soon there. Now, what that means is that the Criminal Cases Review Commission, I will now use the parole board's findings for the CCRC with the hope to then reconsidering whether an amicus curiae should have been appointed. Because you see, where you have a person who is effectively, shall we say, insane, shall we say, is not, but shall we say legally or mentally unstable, you can't have him present a case. Although there are some lawyers, maybe even this one included, at times do act crazy, but the law doesn't allow it. You can't represent yourself if you're not fit to represent yourself. And what the judge should have done is appointed someone to help the court. It happens all the time. It happened in Milosevic. It's happened in Iraq. Happened in Saddam Hussein. Happened in a country where there is no law. Why on earth did it not happen in the case of Bronson? Because if it had, see, Sam's got 8 years, a determinate sentence for false imprisonment, exactly the same offence but worse. Bronson got life. And that's wrong, and that's why people like me will continue to advance this case. David Martin Sperry is also with me here in Rome today. We're actually here to meet to decide the next step in the battle to free Charles Bronson. This is Giovanni Di Stefano for SLI Media, June 2009.